Hi everyone, and welcome back to the University. Today we have 3 parts to one trial date, and that is day 15 of the Raymond Davis trial. This took place on September 13th, 2019. This is the first full day of trial, and we start with testimony of one of the victims in this case. Now, I've broken this down into 3 parts because the total hearing was a little over 6 hours. So, this first part is the opening statements of the prosecutor and of Raymond Davis. Hope you enjoy.
How you doing, Your Honor?
I'm good. 1 second.
How you doing, Ms. Collins?
Okay, we are on the record in C342946, David versus Raymond Davis. Sorry, my computer's taking a second to pull up. While it does, Mr. Davis is present in custody. Standby counsel, Mr. Klaus, is also present. Chief Deputy District Attorney Stacey Collins is present. I received an email yesterday, and I can make sure that everybody has a copy. It's from the psych nurse practitioner that saw Mr. Davis yesterday, and I'll make this as a exhibit. All right, so it states that Mr. Davis' appearance was appropriate, his speech was expressive, his mood was depressed and anxious, that he discussed that he previously had some issues with post-traumatic stress disorder, that it's chronic, but he denies ever have been formally diagnosed with anything. That his affect was cheerful, his thought form was coherent, that his thought content was appropriate, that he was oriented to person, place, purpose, and time, that his memory was intact, that his intelligence is average, that his insight is fair, judgment is fair, his behavior was appropriate. That he did admit that he was being emotional and got tearful and he did get tearful during the assessment, but that he was calm, lucid, and cooperative with the nurse practitioner. That he, and those were, and like I said, I'll make sure everybody has a copy of that. So, Mr. Davis, how are you feeling today, sir?
Your Honor, first off, I would like to issue you an apology for my behavior in your courtroom several times. And not indicative of who I am. I was going through some serious pain with my ankle monitor, and it really, when I got angry and my anxiety going up and stuff, and that was really triggering a lot of my emotions. Also, I'd like to apologize to Mrs. Collins because she didn't deserve the things I said to her. Mrs. Collins, I respectfully, I respect you. I think you've had some people that said some things in your ear that might have led you another way or something like that. But I'm not a bad person. I don't think you're racist. I don't think you're dirty. I think some people make statements to you, and you, I don't know, for whatever reason, you don't check them out and see. And then, you
first of all, I want to tell you that I do appreciate your apologies, and I think that,
And I'll be on my best behavior.
okay, so just one thing that I want to tell you is, trial is, it's a really stressful environment, and I can tell you, having done almost 60 jury trials, that even as an attorney, it gets stressful and emotions get high, and so I understand that. I really do, and I'm compassionate to that, okay? And I appreciate the sentiments that you have expressed this morning. I appreciate your professionalism in speaking with the nurse practitioner yesterday, who stated that you were calm, lucid, cooperative, that you had discussed some things that had happened in your past that you feel have, kind of contributed to this, perhaps like a post-traumatic stress disorder type thing. And so what we're going to do is we're just going to take it slow, day by day. We're going to work through things. And when it starts to get stressful or overwhelming, then I just want you to take some deep breaths.
Yeah, I would like to talk to you and the DA and Chambers, and maybe we can work something out so this don't have to go to trial. I don't want to put 3 juries that have been sexually assaulted through this.
Oh, they're not on the jury.
They're not.
What did you say? I apologize. Maybe I
There's 3
missed you.
females that were sexually assaulted.
Oh, the 3 females that you had talked about before. Oh, I'm sorry. I understand what you're saying. Oh, which brings me to, I need to make sure I understand, say one more thing. One of the jurors that is on has become ill and has missed several days of work because of that. And I'll provide you with an email that he had sent saying, I've been sick for several days, I've missed work. And so I think we're probably in a situation where we're going to have to let him go, which would mean one of the alternate jurors. I think it's either Mr. Mays or Mr. I think it's Harden would then become a juror.
Yes, Your Honor. I'd rather try to work something out with the court before I go to trial and maybe get this over with so I don't have to sit in jail forever. And I mean, I had the understanding that I didn't violate my ankle monitor.
No, I read it, and that's where we're going to get that in a second. So I read your health assessment. I don't have any plans on keeping you in custody during this trial.
Right. Yes, Your Honor. Well, I appreciate that.
My plan would be to release you back to the condition that you were previously in, which would be the house arrest bracelet. I would make sure that they worked with you so that there weren't any issues, and so that you would remain out of custody during the trial.
Your Honor, that is very traumatic, that bracelet. I give you my word, I'm a former military. I have never had an FTA. I have nowhere to run. If I ran, the jury would find me guilty. They can have a trial without me and I'll be found guilty. There's nowhere for me to run. I'm too recognizable. There's nowhere I can go. I never had an FTA. The ankle bracelet is so painful. You just don't understand. And it starts buzzing and beeping.
Well, like I said,
right now I got clear. I'm so clear-headed and I'm so calm. And that putting it on me is like, it reminds me like slavery or something. Just throw something on your ankle and boom.
I know, but I have to, without facts being presented to me that are different, then I have to return you to the situation we were in. So I'm happy to work with you in house arrest to make sure the bracelet isn't an issue, but if you prefer, I can't imagine you would prefer this, but if you prefer to remain in custody so you don't have to deal with that during the trial, I'm happy to do that.
What I won't mind doing is going to the police station every 6 hours, checking in. I won't mind getting up in the middle of the night to go check in.
No, we're not going to do that.
Your Honor, I don't mind doing that because the ankle bracelet is really triggers me. Somehow that thing triggers me.
Well, then
For 5 months I've been triggered. You gotta see my ankle. Look at my ankle. You gotta see this. If I take off my socks. It is so painful you wouldn't believe it. Look at the back of my foot, my heel. Look at that. And look at this, Your Honor. If I encroach.
No, I can see it. Just show me.
Look at the back of my heel. And then look at this, the front of it. And then look at the side of it.
That's why I'm saying, oh, I will have them work with you. But if you would want, I can't imagine you would want this, but would you prefer to stay in?
No, Your Honor.
Okay. All right, Ms. Collins, one thing that he has discussed is wishing to negotiate this matter with you. I remember that you had originally placed on the record an offer, and that offer had been rejected, and then it had been pulled off the table. As you stand here today, are there any offers on the table?
I am willing to discuss offers with him. Any offer I would discuss with him would obviously be a remainder on house arrest. I can't just let him go. But I'm willing to discuss an offer with him through Mr. Klaus and have that explained to him. I would like the court to make findings pursuant to Melcher, that you don't have a reasonable doubt as to his competency, and all of those.
Yeah, so
that.
sure, I'm happy to do that. So competency was never the issue or was never the question. The issue was a mental evaluation because, as he stated on the record, he felt because of my rulings that I was driving him crazy, or I was driving him to have a mental breakdown. I watched 2 days of voir dire where he very effectively issue spotted the issues in his case, went and spoke with each juror appropriately. Not only did he ask appropriate questions, but they then responded. When they responded to him, he would then respond and engage in conversations and question and answering with them. That was, I found, to be very effective. Where things started to kind of deteriorate is when he was frustrated with those individuals that were put on the jury and then his witness list. Like I said, there have never been any questions on his behalf or comments on his behalf or findings on my behalf that his actual competency, whether he understood what was going on in the proceedings, was at issue. The issue was him being frustrated and angry and saying he just wished to have a mental health evaluation. The nurse practitioner yesterday that commonly does the psych assessments found him to be lucid, to be calm, to be cooperative, to be understanding what was going on, and to be able to engage in conversations. I think there was even a part where isn't it true, something, Mr. Davis, that she discussed with you whether or not you understood the charges? You stated that you did, and you understood the penalties if you were to be convicted, that there would be life sentences.
It was a guy, and he was a good guy, nice guy. He hit on a lot of points, but a lot of points he missed from the last assessment I ever had. But he was basically spot on. Besides me saying being joyful, I wasn't.
No, tearful.
I mean,
He did not say you were joyful. He said you were tearful.
Yeah, I teared up a couple times because of, I brought up my past to him and stuff like this. This is why, I mean, Your Honor, I have the utmost respect for you. You know why? Because if I had somebody like you in my life when I was little to fight, you fight for victims that can't fight for themselves. And I wanted to show you, but they didn't bring me my stuff. I wanted to show you all the things that I pay for a month. The St. Jude's, the Shade Tree, the police fund, the 9/11 police fund, the fire fund. I have literally, and it's right in my property, like 10 agencies that I send money to. And one thing that's close to me is kids. And as a kid that was sexually abused and ran through the system, I read your bio. What you did, you're a champion. And I don't want to go to jail. I would want to help somebody like you. I would want to take advantage of my following and my financial resources to help, not to hurt.
So why don't we have Ms. Collins, do you have an offer already in mind that we can place on the record right now that him and Mr. Klaus could discuss?
I do, Your Honor. The state would offer him 1 count of soliciting the minor to engage in prostitution, 1 count of attempt lewdness with a minor under the age of 16. That would be fictitious because that law didn't exist at that time. It would be an underlying stipulated 4 to 10 with probation.
Okay, so Mr. Klaus, would you mind please stepping into the side room and speaking with Mr. Davis about what that means, and then we can come out and discuss it on the record?
Your Honor, if I could have the district attorney send that to me in an email, please, just so I make sure that I get this correct, because I understand that essentially it's a stipulation for prison for 14 years.
No, an underlying sentence.
Underlying.
So it's a stipulation of probation with an underlying sentence of 4 to 10 years.
Yes,
Correct.
it still has to have a psychosexual evaluation. And I don't have your email to send that to you.
Your Honor,
Yeah.
with all due respect to those, I'd rather pay a $50,000 fine.
So I can't get,
I'd rather pay a fine and help, and I'd rather donate money to causes, every cause, and I'm willing, open to helping Ms. Collins in the future and for some things that I understand is going on.
okay, so the one thing about being a judge is I don't get to be involved in the negotiations at all. So if that's the offer, she has, in regards to negotiations, the district attorney has complete discretion. So that is the offer. If you'd like to talk about it with Mr. Klaus, you can. If that's not something you're interested in too, that's fine. I can bring in the jury.
I'd like to talk to Mrs. Collins about it.
Ms. Collins.
Yeah, Mrs. Collins.
Well, I will speak to him with Mr. Klaus. I just want to explain to you, sir, that in the state of Nevada, in Clark County, we don't settle criminal cases for financial contribution. That's not the way it works.
I'm not trying.
So, well, I know, but you wanted to pay a fine, and we don't, that's not how criminal works. That's how civil cases work. When it's you and one party fighting about, property or something, then you settle for money. We don't do that in criminal cases. It involves a plea to a substantially reduced sentence, probation. I mean, I have a constituency that's a reasonable offer in my mind. So if you want to talk some more about it, if you want to.
We can talk some more about it, but your first offer was way better than that.
Well, that was my first offer after we've been in here fighting for a week. I brought victims in, I've talked to them, I've put them through hearings, I've done all those things. I've set aside other trials, I've set aside other victims.
Which witnesses
My
were you?
bad acts motion has been granted so that is going to be.
So that's the offer. Mr. Klaus, would you mind please speaking to Mr. Davis in regards to the offer? And I want to make sure in the negotiations for an attempt lewdness is you have to register as a sex offender and you're also subject to lifetime supervision. Is that correct, Ms. Collins?
That is correct.
All right, so I want to make sure that you understand the full. So, Mr. Klaus, so it'd be those 2 counts. It'd be no opposition to probation. If Mr. Davis failed to stay out of trouble or didn't do well on probation, you'd go to prison for 4 to 10 years. And then the condition of that is he would be a registered sex offender and subject to lifetime supervision. So let's make sure all those are explained.
Yes, Your Honor, I can't do it. Your Honor, with my line of work and my following, registering as a sex offender would be just suicide. I'd be broken on the street.
Okay.
So, I mean, it's a great offer other than that. And like I said, I'm willing to help Ms. Collins in any way I can in the future. I have some things for her that she might be interested in. And I mean, I just think she's a good DA, and I just
So
think.
at this point, would you like to speak to Mr. Klaus or are you rejecting that offer?
I'd like to speak to Mrs. Collins.
I know, but what you're saying is that you can't, I guess what you're saying to me is that you can't be a sex offender, is that right?
Yes, I lose everything.
Ms. Collins, is there any offer that you would offer him where he would not be a sex offender?
With his history, I'm just hard pressed to do that.
So,
And that's my issue. Between Haywood, California, and those charges, we don't. Anyway, I just want to put on the record why that is the case. Between your 2004 case, between the young lady in 2011, and now the current case with 2 victims. So it's very difficult for me with my obligation to my community and my office to give you an offer that doesn't have sex offender registration. Now, those are about the lowest level sex felonies that I have to offer you. I mean, there's not anything less than that, really. That is for me to even say I agree to probation is a huge extension of grace, in my opinion. So you may want to talk to Mr. Klaus about this.
Yes, Mrs. Collins?
Just so I'm clear, we're talking about category E felony, and then the other was category C, the attempt lewdness under 16.
it
I
to
think
a 1 to
mediation
5.
order and the attempt turns it to a seven.
Got it.
Okay, Ms. Collins, with all due respect to that, I appreciate you coming to me, protect the community. But also with that, if you take this case, and then obviously we all heard the testimony of Ms. Nunez, and then we heard the testimony from 2011, the acts that's said in this one is way extreme. So Mrs. Nunez said for herself that I never touched her, I never watched her bathe, I never did this. And the other girl said basically she gave me a blowjob. This one right here is saying I touched her vagina, I touched her boobs, I forced her to give me a blowjob. It's not the same as the 2004 allegations as the 2019 allegations are totally different.
Well, Mr. Davis, with all due respect, you have a history of inappropriately aged sex partners, and that's the way it is. The law looks at it much differently than you do. So I appreciate what you think the differential is. These are the lowest level sex felonies I have access to. I'm promising you probation. One is mandatory probation. That is what I'm willing to do. So if you want to discuss the upsides and downsides of that with Mr. Klaus, discuss what you think you should do. I mean, sex offender registration is not going to be off the table at this point. So
I think I should speak to you in private, and I can.
no, we can't do that.
I mean, if Marshall can do that, obviously. I got information, on a sex trafficking ring in Vegas, and I'm willing to help you save some people's lives that really need to be helped. And I can't do it. I'm registered as a sex offender.
And I appreciate what you're saying, but Ms. Collins has given you the offer. Mr. Klaus, if you wouldn't mind taking him in there and explaining what the deal is? Okay.
I can't take you down.
That's your right. No one can force you, but if you're saying you can't take it, that's fine. So the offer that was placed on the record, you're stating because you have to register as a sex offender, you're not willing to accept. Is that right, sir?
Yes, it destroys me.
Okay. So the next point is I had asked the officers to put you in your clothes that you were wearing yesterday. The jury never saw anybody yesterday, and they told me that you refused.
No, it wasn't my clothes from yesterday.
What was it?
They wanted to put me in some clothes that they had. It wasn't my clothes. I asked them, could I have my clothes?
Oh.
And I
Well, it's
was
slacks and a long sleeve shirt, or a collar shirt, tie.
Oh.
As they typically do.
Okay. So somewhere along the lines it got confused because I asked specifically said that he needed his personal clothes from yesterday.
Yes.
So, is it your choice to be in the clothes that you have right now, or would you like your clothes that you were in yesterday before we proceed?
This is okay. I don't want to waste no more court time, to be honest.
Yesterday.
No, this is fine. This is fine. But I do need my legal papers.
Well, that presents another problem.
Okay. All right. So here's the thing. Your legal papers are in your personal property. Is that correct?
At one point, they couldn't find it in booking, that all my papers was gone.
Okay. Don't worry.
Yesterday, Your Honor, I think we made a record that CCPC has custody of his legal papers.
Yeah, and we'll get them. Don't be worried about it. We'll get them.
Thank you.
But I just want to make sure, because you have a right not to be in what I refer to as blues, right? In jail clothes. But you're saying that that's what you want.
Your Honor, I tried to get my clothes this morning.
Yeah. And I will get them for you. Would you like them?
No, Your Honor, I don't want to waste no more court time.
It's not about court time. You're not wasting my time. If you would like those clothes, we will go get them for you.
That's okay, Your Honor, I really like this.
Okay. I'm gonna have your legal papers brought over to you. Right now, though, I'm just gonna read them the instructions about the trial. And by the time I'm done with the instructions about the trial, your legal papers should be here.
Thank you, Your Honor.
You're welcome. See, Mr. Cios, is there someone over at the jail that can make sure his legal papers, which he would need for opening statements, are available, can be brought over to him?
Yeah,
Is it in his property or?
It should be, the order was that, everything that he left with, which was his legal papers, I think you have like a briefcase, right, Mr. Davis?
It's an accordion file with the snap over, right?
Yeah, you have an accordion file, and then, did you have the bag?
I had the backpack, and then I got the attorney file.
Yeah, and
And
so
then-
I had asked that all of that be put into his, property.
Yeah, and also, the rest of my files that I forgot, they're in my trunk in my car across the street. It's like because you remember yesterday I was scrambling all over trying to find something? And I said, oh my God, I thought I lost it, but it's in my trunk, I'm pretty sure it's in my trunk of my car.
That was for the recusal hearing.
Right,
Right,
right.
yeah.
I couldn't find it, and I needed it.
Well, right, but the recusal hearing is over, so your legal papers that you were prepared with to go forward to tomorrow.
Right, it wasn't for the recusal, those papers wasn't for the recusal hearing, it was for this trial that I'm missing.
Okay, well, I mean,
Because when I spreaded it all out on the table, I noticed, I said, it's missing.
okay, well, has your car been moved?
No,
Your car's still in that same spot?
yes, it's in the parking garage right there.
Okay, and,
The keys in the front pocket of the backpack, Your Honor.
okay, so why don't we get those? We'll get those documents here. Let me do this. Let me do my introductory statements. I'll let Ms. Collins do her opening arguments. Before we do your opening, we'll make sure we have all of your papers here. And then I have to do what's referred to as grand jury returns at 11 o'clock. That'll be a fine time to take a break. And then we'll make sure everything is here. Okay?
Yeah, when we're done today, how would I get out of here? Because they usually take 12 hours, 24 hours to process you out. And,
I'll make an order that you can release.
yeah, but if you make an order that I release, it's still gonna take 24 hours to get me out of there, and I'll miss court.
Well, court's not till Monday. It's Friday. All right, so I do believe that, Mr. Davis's chains should be taken off, please.
Yes, ma'am. Do you mind if we have our sergeant come up here real quick, so you can explain the whole property thing? Because when we go over there, they don't like us digging around in people's property, because things come up missing when we can make this look like a waste claims made. So
Yeah.
can he come up and kind of expedite the whole property thing?
Yeah.
Otherwise, it could take a while.
Got it. Yeah, let's get this thing moving. So if Mr. Davis's chains could be taken off, please? Okay. So do you release one house arrest? I'm gonna hold that back over to Delbert now. Okay. So what we did, the clerk has been nice enough to expedite the paperwork. So you are released to house arrest, so to where we were when we started. And they're starting that paperwork right now, which hopefully will expedite that, okay?
Thank you, I appreciate it.
And they also took his monitor, I guess, at the jail. He doesn't have his house arrest bracelet on now,
Right.
so.
That'll be, so he's released to house arrest, so they know that they'll have to reset it up.
So he'll have to go there after court today on his own.
Actually, Your Honor, it takes 5 days for them to come and get you house arrest.
For what?
It takes them 5 days to come and get you house arrest.
Okay, well, we'll see, we'll talk to them today about what's going on.
Your Honor, the supervisor's coming up, he's on his way up, so when he gets up here, you can explain to him what you requested about his property.
Okay, how long will it take him to
He's
get?
on his way up.
Okay.
He's right downstairs.
Oh, he's downstairs, okay, great. Yes. Okay, so Mr. Davis, I do have a copy of that medical evaluation that I was talking about, Mr. Klaus. Would you mind grabbing this, please? And then I'm marking this as an exhibit. Court seat, please.
Yes, Mr. Davis, are we on the record? Everything has to be right.
That's okay.
Okay,
I would still like to help you out with some things. You know, you might want to keep on with it.
okay. Just so you know, Mr. Davis, as an officer of the court and as a sworn deputy DA, I can't accept any assistance. If you have reports about that you want to give regarding any of the things you mentioned previously, that would have to be put in a police report to as a template for somebody advice.
This one? Oh, no, yeah.
Thank you. Also, Judge, also, Your Honor, is there any witnesses I can have, or am I have any?
So what I need you to do is, maybe at a break today, if you can explain to me, I prefer you do it in writing, so maybe over lunch, and an affidavit explaining why there's a late notice, and then also, you do have to provide Ms. Collins with the last known address. I know everybody's here, so if you want to give her the cell phone numbers, because they do have the opportunity to reach out to them.
She has a cell phone number, two of them. Fred Wolf and Terry King, they put it on the emergency contact. Officer Kelly.
Okay, Officer Kelly has it, but Officer O'Kelly has it, but Ms. Collins doesn't. So put cell numbers on that list,
Right.
and then honestly, at the rate we're going, it might be 5 days. Most people get called anyways, so. But yeah, so let's just provide that. Is the sergeant here? Hi, sir, how are you? Good. Would you mind coming up to just so a microphone can hear you? And your name and P number, please?
Sergeant Coleman, 13843.
Thank you, Sergeant Coleman. So yesterday, we were about to begin trial and the defendant was remanded. And I had stated on the record that I wanted all of his legal papers to be placed into his personal property.
Okay.
Obviously now we're starting the trial again, and so he needs all of his property.
Okay.
So what I asked the CEOs to do is to get everything from his personal property and bring it over because we're about to start trial.
Okay. That would be a records situation. We don't have authorization to go onto his property and just grab his property. That would be a situation where we have to call a records supervisor, and then they would coordinate to get his property for him.
Okay.
I can make a phone call to the records supervisor and see what we can do in this matter. But as far as us doing that, we won't be able to do that, but I can make a phone call to records supervisor.
All right. Would you mind stepping back into my office and making that telephone call with my judicial executive assistant so that she can get on the phone with records and tell them that this needs to be done?
Yes, ma'am.
All right, thank you. Her name is Crystal. She's in my chambers. You can go back. Either way. And my law clerk Nicole can help as well. Thank you.
Judge, there's also the issue with the car keys, releasing them to the marshal.
Yeah.
Yes, and that's an entirely different process because we cannot authorize giving someone else his property. It's a legal thing. So he would have to sign some type of documents giving him
Well,
permission.
once everything's up here and it's in his care and custody and control, then he can have it again.
He can't, can he?
Well, he cannot have his property outside of the facility. This is not considered, this is not our facility.
So I
he's-
released him. Does that make a
Oh,
change?
is he released
He's
from
released.
custody?
Yeah.
Okay, let me make a phone call.
Okay.
I'll be back.
Okay, so, while they're working all that out, can I bring the jury in and give them the instructions?
Yes, Your Honor.
Okay, let's get that done, all right?
Your Honor, have a break and go home and get new clothes?
No.
I'm only 10 minutes away, and 10 minutes left.
All right, you want it?
rise for the entrance of the jury.
Oh, yes. Yeah, I got it.
All members of the jury present, Your Honor.
Thank you. Any questions would approach briefly, please? Would you guys mind approaching? Would you guys rather do my instructions and then call him up? Or would you want to just do it right now with the finish?
You can do it now.
Whichever way, just don't swear him, I guess. Like, you're gonna do your instructions and then talk to him and then swear them after.
Yeah.
Number 6 is up.
Yeah, let me do my instructions and then we'll talk really quick. These instructions are going to take a while, so we'll take them, okay? All right. Good morning, ladies and gentlemen. We are back on the record in state of Nevada versus Raymond Davis, C-342-946. Mr. Davis is present with his standby counsel, Mr. Klaus. Deputy District Attorney, Chief Deputy District Attorney Stacey Collins is also present. Both sides stipulate to the presence of the jury.
Yes, ma'am.
Yes, Your Honor.
All right. So thank you so much for your patience yesterday. Some things came up out of anybody's control, and so I appreciate you coming back today. What I'm going to do right now is read some instructions for you so you can know what to expect, and then we'll take a very brief break, and then we'll roll into what I refer to as, what is referred to as opening statement, okay?
Your Honor, can I approach?
Yes.
I think the jury should know why I'm in blues, like you had like a psychological evaluation, you know what I mean? So they don't think I did something criminally, like went crazy in court or something like that. Right, but I think they should know, because the simple fact that they could say, hey, he went nuts or something, and that makes him look bad. I think they should know that, well, I had a psych evaluation to make sure I was content to stand court, you know? No, I thought she was going to just tell him that I had a psych evaluation, or what, you know? So I could put it in my opening statements.
No. The opening statements are what we plan to prove during trial.
Okay.
Okay? All right, so before we begin the trial, for those who remain as jurors, I want to let you know what you can expect. What I will now say is intended to serve as a general introduction to the trial of this case. It is not a substitute for the detailed instructions in the law, which I will give you at the close of the case and before you retire to consider your verdict. First, we would like you to be as comfortable as possible as you are here as jurors. If you have trouble hearing or seeing at any time during the trial, please go ahead and raise your hand as an indication. Also, if you need to use the restroom, if you feel ill, or if you have any other problems, please also raise your hand as an indication. I also encourage you to stand up and stretch between witnesses or when the attorneys are discussing something up here at the bench with me. You can also feel free to bring in water or any other clear liquid, as long as it doesn't cause any disruption in the proceedings. During trial, we generally, on Thursdays and Fridays, I try to get an entire day in, so usually about a 9:30 start till 5. Mondays, Tuesdays, and Wednesdays, I have full criminal and full civil calendars, which usually take up almost my entire morning. So on those days, at earliest, we start at 11, and at latest, we start at 1. We usually break about every hour and 15 to hour and 30 minutes to get you guys moving around, and if you need a snack and a drink, because I know that it's hard to sit there. What I generally do is take a break at sometime mid-morning, and then you get a break at lunch for the full days, and then a break in the afternoon. So, as I discussed before, this is obviously a criminal case commenced by the state of Nevada, which I may sometimes refer to as the state when I refer to District Attorney Collins, against Mr. Davis. This case is based on an indictment, which the clerk will now read to the ladies and gentlemen of the jury and state the plea of the defendant to that indictment, please.
Yes. District Court, Clark County, Nevada, the state of Nevada plaintiff versus Raymond Davis, defendant. Case C 342946, Department 6, indictment. State of Nevada, County of Clark. The defendant above named Raymond Davis, accused by the Clark County Grand Jury of the crimes of sexual assault with a minor under 14 years of age, lewdness with a child under the age of 14, and open or gross lewdness committed at and within the County of Clark, State of Nevada, on or between January 1st, 2014 and July 23rd, 2015 as follows. Count 1, sexual assault with a minor under 14 years of age. Defendant did then and there willfully, unlawfully, and feloniously sexually assault and subject VR, a child under 14 years of age, to sexual penetration, to wit, fellatio, by placing his penis on and or into the mouth of VR against the will of VR, or under conditions in which defendant knew or should have known that VR was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 2, sexual assault with a minor under 14 years of age. Defendant did then and there willfully, unlawfully, and feloniously sexually assault and subject VR, a child under 14 years of age, to sexual penetration, to wit, fellatio, by placing his penis on and or into the mouth of VR against the will of VR, or under conditions in which defendant knew or should have known that VR was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 3, sexual assault with a minor under 14 years of age. Defendant did then and there willfully, unlawfully, and feloniously sexually assault and subject VR, a child under 14 years of age, to sexual penetration, to wit, fellatio, by placing his penis on and or into the mouth of VR against the will of VR, or under conditions in which defendant knew or should have known that VR was mentally or physically incapable of resisting or understanding the nature of defendant's conduct. Count 4, open or gross lewdness. Defendant did willfully and unlawfully commit an act of open or gross lewdness by using his hands and or fingers to touch and or rub and or fondle and or masturbate his penis in the view of VR. Count 5, lewdness with a child under the age of 14. Defendant did willfully, lewdly, unlawfully, and feloniously commit a lewd or lascivious act upon or with the body or any part or member thereof of a child, to wit, VR, a child under the age of 14 years, by using his hands and or fingers to touch and or rub and or fondle the breast of VR with the intent of arousing, appealing to, or gratifying the lusts, passions, or desires of defendant or VR. Count 6, lewdness with a child under the age of 14. Defendant did willfully, lewdly, unlawfully, and feloniously commit a lewd or lascivious act upon or with the body or any part or member thereof of a child, to wit, VR, a child under the age of 14 years, by using his hands and or fingers to touch and or rub and or fondle the genital area of VR with the intent of arousing, appealing to, or gratifying the lusts, passions, or desires of defendant or VR. Count 7, lewdness with a child under the age of 14. Defendant did willfully, lewdly, unlawfully, and feloniously commit a lewd or lascivious act upon or with the body or any part or member thereof a child, to wit, VR, a child under the age of 14 years, by causing VR to shower and clothe with unclothed CR, another female juvenile, encouraging or directing VR to touch the body of CR and or CR to touch the body of VR, while defendant watched and or masturbated with the intent of arousing, appealing to, or gratifying the lust, passions, or sexual desires of defendant or VR. Count 8. Open or gross lewdness. Defendant did willfully and unlawfully commit an act of open or gross lewdness by using his hands and or fingers to touch and or rub and or fondle and or masturbate his penis in the view of CR. Count 9. Open or gross lewdness. Defendant did willfully and unlawfully commit an act of open or gross lewdness by using his hands and or fingers to touch and or rub and or fondle and or masturbate his penis in the view of VR. Dated this 28th day of August 2019. Signed by Stephen B. Wolfson, Clark County District Attorney, by or Stacy Collins, Chief Deputy District Attorney, to which defendant has entered pleas of not guilty.
Thank you. So please understand the indictment, which is the document that was just read by the clerk, is simply a charging document. It is not, in any sense, evidence of the allegations it contains. The defendant has pled not guilty to those charges in the indictment. The state, therefore, has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. As the defendant sits there now, he is not guilty. The purpose of this trial is to determine whether the state will meet the burden. It is your primary responsibility as jurors to find and determine the facts. Under our system of criminal procedure, you are the sole judge of the facts. You are here to determine the facts from the testimony you hear and other evidence, including exhibits introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. Ladies and gentlemen, you must base your verdict solely on the evidence presented in the courtroom and the instructions on the law that I give you. To protect the integrity of the jury process, it is very important that you do not do any independent research about this case until the jury has reached a final decision. You may not visit any location involved in this case. You must not do any research or look up words, names, maps, or anything else that may have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any other means to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. Additionally, until you are discharged from service as a juror, you must not provide or receive any information about your jury service to anyone, including friends, co-workers, and family. You may tell people that you have been picked for a jury and how long the case will take. However, you must not give any information about the case itself or the people involved in the case. You must also warn people not to try to say anything to you or write to you about your jury service or the case. This includes face-to-face, phone, or computer communication. In this age of electronic communications, I want to stress that you must not use electronic devices or computers to research or talk about this case, including Googling, tweeting, Facebooking, texting, blogging, emailing, posting information on a website, or any other means at all. All of us are depending on you to follow these rules so that there will be a fair and lawful resolution of this case. If we find out that any of this is happening, we actually have to start this entire process over and pick a jury from scratch, which takes actually a lot of time and money. And so please, please, please follow these rules. You may not declare to your fellow jurors any facts relating to this case of your own knowledge. And if you discover during the trial or after the jury has retired that you or any other jurors have personal knowledge of any witness or fact in controversy in this case, you must disclose that information to me outside the presence of the other jurors. The trial process, or the way that things unfold, go like this. The trial begins with what's referred to as opening statements. The district attorney will make an opening statement if she so desires, which is an outline to help you understand what the state expects to prove. Next, Mr. Davis, if he so desires, may make an opening statement, but he does not have to do so. Opening statements serve as an introduction to the evidence, which the party making the statement intends to prove, but they are not in and of themselves evidence. The state would still have to prove what they're saying they intend to prove during the trial. That next comes the presentation of evidence. The state will commence with what's referred to as its case in chief. This is the state's opportunity to present its evidence. This consists of the calling of witnesses and the production of physical items of evidence such as documents or photographs, things like that. Counsel for the defendant, Mr. Davis, may cross-examine the state's witnesses. Following the state's case in chief, the defendant, if he so wishes, may present evidence that the district attorneys may cross-examine the defense witnesses on. However, as I have said, the defendant is not obligated to present any evidence in any case. Then there's what's referred to as rebuttal evidence. If Mr. Davis does present evidence, the state will then have the opportunity to present rebuttal evidence. And the defendant, if he chooses, may also have the opportunity to present surrebuttal evidence. The evidence in this case will consist of sworn testimony of witnesses, exhibits that will be received in evidence, regardless of which side introduces the evidence. If the state or the defense if they both stipulate to the existence that a fact occurred, you must, unless otherwise instructed, accept that stipulation as evidence and regard that fact as proven. I may take judicial notice of certain facts or events. If I take judicial notice of a fact or event, you must accept that fact as true. So if, let's say Ms. Collins or Mr. Davis said, Judge, I'd ask you to take judicial notice that May 2nd of 2015 fell on a Tuesday. I would then Google really quick, make sure that May 2nd of 2015 fell on a Tuesday, and then I would take judicial notice of that, meaning you guys could then rely on that, knowing that I looked it up and I know that that date is a Tuesday. Okay? In every case, there are two types of evidence. There's what's referred to as direct evidence and circumstantial evidence. Circumstantial evidence is testimony or exhibits which are proof of a particular fact from which, if that fact is proven, you can infer the existence of the second fact. So the easiest way to explain this is between direct and circumstantial is, let's say you're driving home tonight and rain starts to fall, and it starts to fall on your window, and you actually see it with your eyes. That's what's referred to as direct evidence. You're directly seeing that. Circumstantial is different. Let's say on your way home, you see the gray thunderclouds starting to build, you see maybe some lightning going on. You can tell that a storm's coming, but you go home and you go to bed. When you wake up, there's water on your car, there's water on the grass, there's water down your street. Now, you didn't see that it actually rained. But when you consider all of the circumstances, the fact that you saw the gray thunderclouds building, you heard some thunder, lightning, and when you wake up, there's water everywhere, you can consider that as circumstantial evidence that it rained. You may consider both direct and circumstantial evidence in deciding the case. It's also important that you know that the law permits you to give equal weight to both types of evidence. But it is up to you to decide how much weight to give each piece of evidence. Let's talk a little bit about objections. So the parties may sometimes make objections to some of the testimony or other evidence. It is the duty of the parties to object to evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way because one of the parties makes an objection on their behalf. At times, I may sustain objections or direct that you disregard certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. You must also not consider anything which you may have seen or heard when the court is not in session, even if what you see or hear is said or done by one of the parties or by one of the witnesses. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, if any, the relation of the witness to the defendant or the state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements and all of the facts and circumstances and evidence. Thus, you may give the testimony of any witness the weight and value you believe the testimony of the witness is entitled to receive. At the conclusion of the evidence, I will instruct you on the law in this case. You must not be concerned with the wisdom of any rule of law stated in these instructions or the instructions that I will read to you after the evidence is in. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given to you by the court. Until the case is submitted to you, you must not discuss it with anyone, even with your fellow jurors. After it is submitted to you, you must discuss it only in the jury room with your fellow jurors. It is important that you keep an open mind and not decide any issue in the case until the entire case has been submitted to you under instructions from me. Again, if you discover during the course of the trial that you have personal knowledge of the facts of the case or that you know one of the witnesses or the parties, please give a note to the marshal who will present it to me. After the instructions have been read to you, each side will have the opportunity to present closing arguments. What is said in closing arguments, again, is not evidence. Just like opening statements are not evidence. The arguments are designed to summarize and interpret the evidence while discussing with you how to apply the law to the facts of the case. Since the state has the burden of proving the defendant guilty beyond a reasonable doubt, the state has the right to open and close the arguments. This means the state will make a closing argument, followed by a closing argument from the defendant, and then the state may make a rebuttal closing argument. After the arguments have been completed, you will retire to deliberate on your verdict. During the trial, it may be necessary for me to confer with the parties at the bench about questions of law or procedure that I need to make a decision on. Sometimes you may be excused from the courtroom for the same reason. I will try to limit these interruptions as much as possible, but please understand if we take a break, it is necessary, and we appreciate your patience. So, I have been a juror before, and I know how frustrating it is to sit out there and to wait when you're told, hey, be here at 10:15, and then we don't get started until 10:45. Or if I say, we're going to be in recess for 15 minutes, and it ends up being 25 minutes. I get it. I was so frustrated by that as a juror. But what you don't know as a juror is that when you're out there having recess, we're all still working on instructions on law and case things. So we're never in here having a party or having snacks or anything like that. We're actually taking care of stuff in here so that once you get in here, we can go and make this thing move. So I apologize. Please know that it's a part of the court process, and we're working as hard as we can to speed things up, okay? You'll be given a badge, which you've already received, to wear during your jury service. Please wear the badge at all times while you are in the courthouse or on a break. This badge lets everyone know that you are a juror in the case. This is important because during the course of this trial, neither side or court personnel other than the marshal are permitted to talk to members of the jury. By this I mean not only can they not talk about the case, but they cannot talk to you at all, not even to ask the time of day. The badge helps them to identify you as a juror. If someone does not talk to you, please understand they are not being rude. To ensure that absolute impartiality of the jury, the people involved in the case are bound by ethics and law to avoid contact with jurors until the case is decided. And sometimes this is so awkward because you'll see one of the parties at the elevator or you'll see them out front, and if you say hi, they won't respond back because there are ethical rules that prevent them from speaking or communicating to you in any way. So please don't hold it against them and think that they're being rude. They're simply following the rules. Next to your seat, you should find a paper and pens for your use. You guys have already been given yours. All right, perfect. You are free to take notes during the trial if you wish, but please keep the notes to yourself until you and your fellow jurors go to the jury room to decide the case. Do not let note-taking distract you. You also should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. If jurors have conflicting notes, you should not rely on the notes because the court recorder's record contains the complete and authentic record of the trial. I probably will take a lot of notes during the trial. Sometimes I'm working on this trial, and sometimes I'm listening and working on my other court calendars. Please don't consider anything that I do up here in any way. If you see me typing notes when someone's talking, it's not because I believe that person more. It's just because I'm either taking notes for a legal reason or I'm actually working on something else. So don't really pay attention to me up here. In fact, you are not to consider anything I say or do or anything during this trial that suggests that I am inclined to favor the claims or position of any party. I am required to remain neutral. It would be wrong for you to conclude that anything I say or do means I am for one side or another in trial. Discussing and deciding the facts is your job and your job alone. Jurors are allowed to ask questions like I explained in the voir dire process in my department. So how it works is as soon as the parties are done asking questions, I'll turn to the jury and I will say, does any member of the jury have a question? If you do, you simply write it out on your pad. Each question has to be done on a separate piece of paper. So you'll write out your question and then you will put, you'll sign it, or no, you'll just put your badge number on it. So it'll be, when I say badge number, I mean what juror you are. So juror 1, 2, 3, 4, 5, 6, all right? Once you're done, the marshal will then bring the question up to me. I'll call the parties to the bench, and I'll read the questions. Questions must be factual in nature and designed to clarify information already presented. If it's a proper question under court rules, I will ask it. If the evidence rules prevent me from asking the question, then I won't ask it. If I don't ask the question, I'll keep the question and explain it after trial, the purpose of the rule that precluded from asking it if you so wish me to do so. Please reserve your questions until the attorneys have finished asking questions of the witness, as the attorneys will likely ask your questions. Jurors must not place undue weight on the responses to their questions or draw any conclusions because a question was not asked. And I believe I had already asked Ms. Collins and Mr. Davis, but there will not be any use of translators in this trial, correct?
That is correct, Your Honor.
Mr. Davis, will there be any witnesses that require a translator?
No. Thank you, Your Honor.
You're welcome. Finally, in fairness to the parties to this case, you should keep an open mind throughout this trial, reaching your conclusion only during your final deliberations, after all the evidence is in and you have heard the attorney's closing arguments and my instructions to you on the law. All right, so in a moment, we're going to start with opening statements, and before that I'm going to do an administration of juror oath, but before that we're going to take a quick break, and I need to, if juror number 6, if you would mind staying in the courtroom, please, and everybody else will just take a quick break, so just stay outside, it should be less than 10 minutes. Oh, you know what, and I apologize, every time you guys leave here, I have to read this same admonishment. During the recess, you're admonished not to talk or converse among yourselves or with anyone else on any subject connected to this trial, or read, watch, or listen to any report or warrant or commentary on the trial of any person connected with this trial by any medium of information, including without limitation to newspapers, television, the internet, and radio, or form or express any opinion on any subject connected with the trial until the case is found and submitted to you. Please leave your notebooks. Those always remain in the courtroom until you go to deliberate, and they can go back with you, but until then, they remain in your seat. All right, you're excused. Thank you.
All rise for the exiting jury.
We are outside the presence, and I asked Mr. Blomgren, which is juror number 6, to stay, because yesterday I had received an email from Jury Services, and I just want to make sure I have it. Just 1 second. That you were talking, so you've been pretty sick the last few days.
Yeah.
And it's basically getting worse is what you explained. And then also, there was some issues about financial hardship because you have been sick and your fiance is pregnant and you're the only one making money in your home. Do I have all that right?
Yes, Your Honor.
Okay. So, it was my understanding that you stated that you were sorry to inform us that you could no longer be a juror in this trial. Do I have everything right?
Yes.
Okay. So, it's always hard when someone says this to me, like after they've already been selected, because you hadn't raised your hand before and explained any of this. So what happened in the interim?
I was thinking that you were going to ask if there's any reason that I could not be a juror, and I thought like when you asked for like medical complications, I thought you meant like if I'm taking any like painkillers or drugs or any of that, or like surgery or something like that.
So explain to me a little bit in regards to what's going on now. I mean, obviously I read about it in the email, but can you give me a little more information?
Yeah. Me and my girlfriend, or me and my fiance last night, we were tossing and turning. We kept going to the bathroom, throwing up, and it was hard to sleep. And we tried drinking water, trying to eat, and we just keep throwing it back up. And
Yeah, to be honest with you, and I don't mean to be disrespectful, you don't look very good today.
yeah, I'm sorry.
No, that's okay. It just seems like you look sick to me.
Yeah.
Yeah, you look like you are sick to me. Miss Collins, do you have any questions for this juror?
No, sir.
Okay.
No, sir.
Sorry. Mr. Davis, do you have any questions for this juror?
No, wish you good well, my friend.
Okay. All right. So would you mind going ahead and stepping out so I can talk to the parties, and then I'll have my marshal speak to you in a moment, okay?
Okay.
Thank you.
Thanks.
All right, so obviously we heard the representations that Mr. Blomgren had. I'm happy to hear from each of the parties in regards to their position, Ms. Collins.
Your Honor, obviously I wouldn't expect him to stay under those circumstances, so I would just ask that you use it all.
Okay.
I actually wanted him to stay and rather not use an alternate.
Okay, so this is why sometimes I have a hard time with understanding you, is because you've been so upset this whole time because an African-American male isn't on this jury. Mr. Blomgren is then asking to get off because he's throwing up, which would then put one of the African-American males that you've wanted this entire time on the jury, would put them on the jury.
The two African-American males that you're speaking of, I'm not fond of neither one of them. So I would like a different selection on one of those two alternates. Also, it came to my attention while I was looking at him, number 8 kept staring at me when they were reading my alleged charges, when the clerk was reading my alleged charges. He stared me down and he kept on shaking his head violently. That to me indicates that I don't think he can be fair and impartial. It seemed like he was convicting me during the clerk's reading. And it was the whole time. It wasn't a break in between. Even my standby counsel noticed it. So I moved to remove him also. Right.
Okay, so I was reading the entire time, and I did see several jurors watching both the state as well as you during reading, which is pretty common. But I never saw juror number 8 making any shakings of head or anything like that. I also always ask my marshal to watch them 100% of the time. Marshal O'Kelly, did you ever see juror number 8 making any head shaking?
No, Your Honor, I did see him looking at the defendant.
Okay.
Not the entire time, but I did see him.
When I stand by attorney's office.
Mr. Klaus, did you see him shaking his head?
Yes, Your Honor. During the reading of the indictment, he was shaking his head back and forth and then making what I can only describe as bad faces during the reading of the charges themselves. I thought I recalled him putting his hands to his temples at one point even. And then after, Your Honor, the indictment was done being read by the clerk, excuse me, and the court started in the jury instructions, he spent the majority of the time staring at us until the court got to the point of the jury instructions reading that if they're unable to reach a verdict, that a new jury will need to be called and sit in their place. Someone will have to make that determination. At that point, he started splitting his attention between the court and between looking back at Mr. Davis.
Okay, all right. So why don't we call, and I do believe you guys are actually, number 8 is a female, so the person next to him would be the next male. Is that Mr. Cerrone?
I think so, Your Honor, but I've double counted that a number of times. I wasn't sure who I was.
Well, does he have tattoos or no tattoos?
Tattoos, Your Honor.
That would be Mr. Cerrone. So let's call him in, please.
Okay.
And as a poker player, stare down is never good.
Okay, so we'll bring him in and we'll just talk
So
with
is
him.
Saram number 9 then?
That's what the sheet says.
Yeah, we were looking at the numbers and it seemed like we were off on some numbers.
Just the person, Your Honor. I think
So if
court
it's the
corrected
person with the
it's Mr.
tattoos,
Saram. Yes.
Mr. Cerrone, from Australia with the British accent?
I did not pay as much attention during jury selection as I should have, Your Honor. I
That is correct.
Okay.
For the record, the state didn't see it, but I was not.
Okay. Mr. Cerrone, just go ahead and have a seat wherever you're comfortable, sir. Thank you. Okay. All right, everybody can have a seat and get comfortable. Thank you. Thank you, Mr. Cerrone. So, in regards to when I was, there was an indication made that at some point during either the reading of the charges that you may have like shook your head, or I apologize, I didn't see it, so that you may have shook your head at some of the charges. Did you do that, or no, you didn't do that?
I did.
You did, okay. Did you hear, I just want to make sure that we're on the same page. Did you hear my, when I was discussing that the charging document is merely that? It's merely
Absolutely, yes.
accusations, and it's merely just a charging document? Do you agree with that?
Yes.
Okay. Do you agree with those principles that I had spoken about in voir dire, that as the defendant sits here right now, he is innocent until proven guilty?
Yes.
Do you believe in that?
Yes.
Okay. And do you believe in the fact that Ms. Collins, as the district attorney, she has to prove beyond a reasonable doubt that the defendant committed these crimes in order for the jury to find him guilty?
Yes.
Do you believe in that?
Yes.
Are you comfortable with doing that?
Absolutely.
Okay. And so, Ms. Collins, do you have any follow-up in regards to questions for Mr. Sorrell?
You have not made any prejudgment on the evidence because you haven't heard anything yet, is that correct?
And as Mr. Davis sits here, do you believe in the premise that as he sits here right now, he is innocent of the charges? Okay. Mr. Davis, do you have any questions?
Yes. I take shaking, when somebody's reading a victim statement like that, I take shaking of the head as, and mean mugging me, scaring me down as you're not liking it. No disrespect, I don't know, I'm not in your head, I don't know why you would shake your head or why you would stare me down. But to me, those actions reflect that you cannot be fair, that you already made judgment on me. And I don't think I can have a fair trial.
Is there a question or consider the statement?
So I just,
So is your question, can you receive a fair trial with him on the jury?
yes, can I receive a fair trial with you?
Absolutely.
Then why would you be shaking your head when you read?
Because it's not a good thing.
It's not a good thing. That's not a good answer, Your Honor.
When you say it's not a good thing, you mean the language that was read?
Right.
Right. So were you shaking your head at the language, or were you shaking your head that the defendant did that?
Just mostly the language. Just, I'm not around that all the time. I'm around kids. It's good.
Okay. But, and I apologize, I don't want you to feel like I'm asking you multiple questions. As the defendant sits here today, in your mind, he is what?
Innocent.
Okay. Anything else, Mr. Davis?
So, I'm trying to word it in a way that if I'm innocent, why so much displeasure during the reading?
It's not a good thing to hear.
Yeah. Were you uncomfortable with it?
Yeah.
Very uncomfortable. Is it going to be a problem to hear much more of this?
No, it's expected. I'm ready for it. I'm here.
Do you know that your reaction could affect other jurors?
We're all going to have our reactions. I'm here to make, I'm here to decide for me. I will listen. So.
I'm going to ask
Okay,
this
just 1 second. Are you done with the questions for
Yes.
Mr. Cerrone? Okay, Mr. Cerrone, thank you so much. If you wouldn't mind stepping outside.
Your Honor, my apologies, it was not Mr. Cerrone that I saw looking at the defendant.
Oh, okay, yeah, no,
Completely different juror.
Okay.
That's why I insisted that he wasn't shaking his head as a different juror.
all right. So, there has been some confusion in regards to what number Mr. Cerrone is. But, so everybody knows, on the juror list, he is number 9. Okay, so I'm happy to hear from the state and Mr. Davis in regards to any representations that you'd like to make into Mr. Cerrone. I'll start with the state and then Mr. Davis.
Your Honor, he said several times he could be fair. He did say he had a reaction to the content of the indictment. I don't think that's unusual. People have an adverse reaction to charges in criminal cases all the time. Anything from homicide to this kind of case to an act of violence. So, he said he reacted to the words, not to the defendant. He said multiple times he could be fair. That's committed to the court. I don't think it is risen to the level where he needs to be.
Mr. Davis?
Yes, Your Honor. I really feel uncomfortable with him. Some of his answers were very disturbing. And then before he got out of the room, I asked the state to remove him. I think him hearing that.
You mean ask the court to remove him?
Right. Yeah. I think it was accidentally. It was a big mistake for me to say that before he gets out the room. But I really think that really prejudiced him against me. Because he's hearing me want to get rid of him.
Oh, no, I stopped you. I stopped you before you said Your Honor, and I said, just 1 second, Mr. Davis, and I let him go. So here's the thing in regards to the jurors. I just cannot keep Mr. Blomgren when he has been up throwing up all night, and he looks so bad. You guys, I feel bad that I even had to bring him in today, to be honest with you. He's been up throwing up all night. He looks so pale. His eyes are so red. I'm going to release him, which would make juror number 13, Corey Harden, now on the jury. In regards to Mr. Joshua Cerrone, juror number 9, what he said and what rang through to the court is that those charges in the indictment, that those were... sometimes those are difficult to hear from jurors, but I also asked him if he understood that those were merely allegations, that I asked him twice if you were, as you sat here today, if he believed that you were innocent until proven guilty. He stated both times yes. I even said to him, as Mr. Davis sits here, he is what to you? He said, I believe he's innocent. And then I explained to him that Ms. Collins has to prove this case on each of the charges, what's referred to as beyond a reasonable doubt, and if he believed in that, and he said yes. So at this point in time, I feel confident in the answers that he gave, that he can be fair, so he is going to remain on the jury.
Your Honor, I would like to put it on the record that when I said I want the courts to remove him, that he was still in the court. He was basically right there, and that's when I turned around and noticed him. And he was still there when I said, basically, I wanted him gone.
Well, actually, before he even got to you, you said, Your Honor, I am. And I said, just 1 second, Mr. Davis, and he walked out.
Your Honor, if we can play back the tape of that or the transcript of that.
So the record, as well in CD, DVD form, as well as the transcript, is always part of the court's record. Which brings me to another point, is I had time yesterday to pull the transcript of Ms. Witt, the jury commissioner, and that was made because you were challenging the cross-section of the community and how this jury was comprised. I had that exhibit marked. I've also had a copy made for you to look at, as well as Ms. Collins, and I'll bring that in. I looked at the numbers in this jury, and I looked at the case law presented in both the Morgan case, which is a Nevada Supreme Court case, as well as, I believe it's Duran versus Missouri, which is a United States Supreme Court. I considered applying that. I looked at the numbers. I also looked at the fact of that on this jury right now, there are 8 African Americans, 6 women, 2 men. So I did make that a part of the record pursuant to Ms. Collins' request yesterday. So I do see that the sergeant is back. Sir, what's going on with the adjustment?
So as far as his legal material from his property, we do have it here.
Wonderful.
It is in bags, so he's not going to be allowed to go through the bags. He can tell us what's in there. We'll give him the documents. As far as his car keys, we cannot do that. He's technically still in our custody. Only person he can release his property to outside of custody would be family, and it's either all or nothing. So we cannot authorize just the car keys.
And what if it's pursuant to court order, written court order?
If you want to write a court order, I can take it over there, but that's a record supervisor.
I get it.
They
I'm
have
not
their
trying to-
protocol.
I'm not trying to put you
I
in
mean,
that spot.
if you write if you make a court order, I can give it to the record supervisor, they can make that determination, it wouldn't be mine.
Okay, Mr. Davis.
Your Honor, basically, I probably don't need what's in the car, so that's not a big issue with the keys.
Okay,
But what I do need is my access to all my legal documents
Okay.
because I'm pro per. So,
that's great. So they're gonna bring the bag over, you explain to them what was in there, and they're gonna give it to you.
and also, I need my phone because I need to put the phone numbers on the witness list. I need all the numbers. So
Okay,
I
we'll
need
get
my
all
phone,
that.
my copy.
May I go to the meeting?
Of course, of course.
Yes, Your Honor.
One second, we are back on record in C 342946, State of Nevada versus Raymond Davis. He's present in custody with Mr. Klaus on his behalf as standby counsel. Chief Deputy District Attorney Ms. Collins on behalf of the state. Mr. Davis, I'm sorry, go ahead.
Yes, Your Honor. Due to my incarceration last night, I wasn't provided a pen and pencil, so I had none of my law stuff, and therefore I couldn't write an opening statement, which is going to be rather long.
So the opening statement doesn't have to do with law, it's the facts you intend to prove.
Right, I understand that, but still I cannot possibly get an opening statement figured out by today.
Okay, so are you choosing to defer your opening then until the end of the state's case?
No, I'd like to defer it till Monday.
No, we're not, something you have to learn, Mr. Davis, is you can't continue to delay these proceedings. So you have two choices today. You can give your opening argument after Ms. Collins gives hers, or you can defer your opening until you intend to present your case in chief.
So I would do my opening with my closing, or?
So basically, you intend to call certain witnesses, right?
Mm-hmm.
So you would do your opening statement before you call your witnesses.
Before I call my first witness?
Correct.
Okay, I have no problem going first before I call my first witness.
Okay, that sounds good. Ms. Collins, are you ready with
Can
your
I get my witness in today, if possible?
So no, the state's gonna do all of their witnesses, and then you're gonna start.
Your Honor, I'd like to have my witness list filed with the clerk.
Okay.
Thank you. And also, Your Honor, I'd like to challenge the statute of limitations on this grand jury indictment. It seems to be well over the statute of limitations for the grand jury indictment. I ask that this case, count 1 through 9, be dismissed due to the fact of the untimely expired statute of limitation in this case.
So if you're going to file a motion to dismiss challenging the court's jurisdiction, then if you could please prepare an affidavit explaining why it is not filed within 10 days of the jury trial commencing, and then have your motion attached, and I'll consider that on Monday. All right. Ms. Holmes, are you ready to proceed? Yes. Bring them in, please.
And Your Honor, if the court wants to let me open and give him some time to prepare an opening statement in between, I don't have a problem.
Okay.
All rise for the entrance of the jury.
of you do solemnly swear that you will well and truly try the case at issue and a true verdict render according to the evidence, so help you God?
Yes.
Thank you.
All right, the trial will now begin with opening statements by Ms. Collins.
Good morning. Thank you for your patience again on behalf of the Clark County District Attorney's Office, more specifically the Special Victims Unit. I want to thank you for your time and attention. I want to echo what Judge Bluth told you, in that when you were outside waiting for us, we were working diligently to get things moving for you and make sure everything is going to occur appropriately. So I thank you for your patience in advance. This case really centers around a young lady by the name of Vanessa Robinson. Vanessa is now 18 years old. In July of 2015, Vanessa was 14 years old. And Vanessa came from not the most supportive family, not the best background, and as many adolescents do, got herself in some trouble. So in July of 2015, she is in juvenile hall. She is there on a probation violation for her juvenile offenses. And you will learn that here in Clark County, there's a woman by the name of Esther Brown. Esther Brown runs an organization called the Embracing Project. The Embracing Project reaches out to teens, and she teaches things such as life skills and stress management and things to teens that are in trouble. She also provides, and has run for several years, a drop-in center for teens that have been the victims of sex trafficking or sex abuse. But as part of her services to this community over many years, she goes to juvenile detention and she talks to kids that are in juvenile detention. And on one particular day, June 22nd of 2018, when Vanessa Robinson was in custody in juvenile hall, she counseled a group of youth, talked to them about these types of things. And after that meeting concluded, Vanessa thought about what she had to say, and Vanessa went to Ms. Brown and said, yes, there was a time that I took money in exchange for sex from a man named Ray Davis. At the time, Vanessa was 14, and so she told Esther just a little bit of the information, and Ms. Brown, which she is obligated to do, calls the Las Vegas Metropolitan Police Department, and she reports that she has a kid disclosing sex abuse by an elderly gentleman, but she doesn't know who it is. And it's not Ms. Brown's job to investigate. She's just mandatory reporting. It's not her job to investigate. So then the investigation starts.
I object.
Did you want to approach regarding your objection?
Yes.
Thank you.
Your Honor, the claims on this allegation is from 2014, which would make her obviously 13, which one charges 1 through 6 is 13 and under. 14 and under. Mrs. Collins opened with claims of 14 in 2015. She hasn't hit. She said she basically said VR. Vanessa came. She basically said VR came in contact with me in 2015, but the charging document said she came in contact with me in 2014. So the age difference of what I'm trying to get at is she has to. She don't have to if she can't, but what I'm asking her to do is put the crime in the 2014 because that's the age she's 13, not the age for charges 1 through 6. Not,
Not a legal objection. What he objected to is I said the investigation started thereafter on July 23rd of 2015. And Vanessa was 14 in July of 15. So this is a factual argument, not a legal objection. So
basically, if you have a disagreement about the facts, and that's
Right.
something that you can bring up in opening saying, I plan to prove that. But in regards to objection, you can't really object over the facts because that's what she intends to prove, and you intend to prove the or you intend to disprove, right, or show the opposite.
Right.
So, the objection is overruled. These are opening statements where each party plans to prove their case in chief.
Your Honor, what I'm objecting to is the fact is that this, I mean, she's not showing that this, she's saying that I met Vanessa in 2015, basically.
I understand that, but what I'm telling you is you two disagree on that point, right? So that's something that you can talk to the jury about, but she gets to say what she plans to prove.
Right. So if she, okay, I understand that. So now if she's saying it's only 2015 is when I came in contact with Vanessa.
That's not what she said. She said an investigation.
Yeah, she said I got that from July 23rd. I got that part. What I'm saying is she's saying that if this all allegedly happened in 2015, that would make her never 14.
She's saying you're not listening to me. She's saying an investigation began.
Okay, yes, Your Honor.
These are factual objections. They're noted for the record. They're overruled. Please go back to the table. Thank you.
On July 23rd of 2015, Vanessa is still in juvenile custody, and she is transported for an interview. She does an interview at the...
I object, Mayor Pro.
We have to approach them.
I think we should.
Your Honor, she's saying that she was transferred to the thing. Well, that's not a fact. The fact is she was in custody.
These are not legal objections. You disagree with facts. You can talk about your facts when you do your opening. These are not legal objections. This is what she plans to prove. So if you have an objection, I want you to object to legal objection. A disagreement about the facts is not a legal objection. It is overruled. Back to your desk.
July 23rd of 2015, Vanessa Robinson was interviewed, and she disclosed that she met a man by the name of Raymond Davis, that she met him on Facebook, that meeting on Facebook through messaging eventually turned into a face-to-face meeting in 2014. She met him at a Whataburger. They continued to communicate via Facebook Messenger. Eventually...
I object, Your Honor. Can I approach?
In regards to facts?
Yes, in regard to facts.
Okay, so in regards to facts, this is what Ms. Collins plans to prove during her case in chief. So the objection is overruled. Ms. Collins, please proceed. Thank you.
Vanessa goes on to say how this person, she eventually goes to his home. It is an apartment off of Nellis, that on several occasions there is an exchange of money for oral sex, that on at least one occasion he has her take a shower with another young lady by the name of China Rowells. He has these unclothed women touch each other while he masturbates in their presence. Vanessa explained back then that the oral sex exchange happened about 10 times, although she doesn't have a specific memory, reel to reel, of each of those times. Vanessa, getting no reward for her disclosure after her interview with the police, is sentenced to a period of time in Caliente. She goes to Caliente. At this time, Metro doesn't know who Ray Davis is, so they begin to look, and they find a Ray Davis that they believe matches Vanessa's description. They compose a photo lineup. They send that photo lineup to Vanessa while she's in custody, so she's shown that photo lineup while she's in custody by a worker at Caliente. His name is Tyler. He will be here for you. Vanessa concludes her time in Caliente. Detective Martinez continues to investigate, and he interviews a young girl by the name of Adriana Walker. Adriana Walker tells Detective Martinez that there was at least one occasion where she was over there and the defendant invited both of them to shower in exchange for money, and Adriana refused to do so. Vanessa Robinson is now 18 years old. She's in school. She's no longer in Caliente. You will also hear from a young lady by the name of Haley Ferris. The judge is going to tell you Haley Ferris is not a charged victim in this case. The court is going to tell you the appropriate purpose for which you may consider that information. In 2011, Haley Ferris was a runaway. She was panhandling on Fremont Street. She was befriended by Mr. Davis. Mr. Davis took her to eat. Mr. Davis provided her a hotel room and a cell phone. She was a runaway at this time. And in exchange for the shelter and the food and the phone, she gave Mr. Davis royalty. No case was ever filed in that regard. Ms. Ferris was picked up for curfew violation back on May 2nd of 2011. She told a police officer about a man she met, but no investigation went any farther. You're going to hear from a young lady by the name of Erica Munoz. In 2004, the defendant was present here in Las Vegas. He purchased 2 bus tickets for a 15-year-old and 14-year-old to travel from California, one by the name of Ashley, one by the name of Erica. We got hotel rooms for them here. Ashley was a runaway, and Erica had basically snuck from California to travel with her friend. They end up with the defendant. They're provided a hotel room. There is an instance where Erica gets in the shower. Ashley joins her in the shower. And when they exit, the defendant is there on the bed in the hotel room. There is discussion about exchange of $1,000 if I touch you, $100 if I don't touch you. Erica becomes afraid. Defendant says, I won't hurt you. Erica departs before anything can happen. And the judge will also tell you the appropriate, that is not a charged victim in this case, but the judge will tell you what you may consider that evidence for when you go back to deliberate. That is the substance of the state's case. You will hear from Vanessa Robinson. You will hear from China Rolls. You will hear from Haley Ferris, the young woman from 2011. You will hear from Erica Munoz, who's now 30 years old, from the case in 2004. The state submits to you that at the conclusion of that evidence, we will return verdicts of guilty. Thank you.
Thank you, Ms. Collins. Can the judge report, please?
as my director, he didn't have time, but that he'd be okay with doing it later. So I just want to make it clear that the state's willing to afford him if he wants some time.
I could probably do it off the top of my head.
Okay, so would you like to take lunch right now and do it over and put some thoughts together over?
No, I'd like to do an opening right now.
Okay, all right.
Thank you, Your Honor.
You're welcome. Okay, Mr. Davis, the floor is yours when you are ready, sir.
Good evening. There's a key word in our judicial system that some people have a hard time comprehending. It's called beyond a reasonable doubt. I will prove to you that beyond a reasonable doubt that these crimes never happened. The state has given you dates, and I hope you guys took the time to write down those dates that the state gave you. I would prove that the state dates were wrong. I will also prove that the dates, location, does not exist. I will prove beyond a reasonable doubt with photos, with inbox messages on Facebook, that the years do not match. I will prove beyond a reasonable doubt that the state case is based on lies. Not only is it based on lies, it is based on made-up dates. It is based on made-up locations. You will not see anyone besides her alleged friend. You will not see camera, video. You will not see traffic lights. You will not see crime scene photos. Those are things you will not see. The reason why you will not see those things is because they don't exist. If you think our fine law enforcement that I have 100% respect for do not do the best job possible to prove that somebody did something. I want you to listen to Detective Martinez's statement when if he takes the stand, and see how much different it is, and see how much work he did. What you guys also heard is the investigation started in 2015. You guys heard that from the prosecutor. We are now in 2019. The defendant hasn't moved. The defendant is a well-known figure in the gaming world. The defendant is a world-class poker player. The defendant owns a store on the Vegas Strip. The defendant drives a red Camaro with custom plates that says RG. That does not sound like somebody that would hide to me or be hard to find, when, in fact, anyone can find me with a simple Google search. Or they can find me on TV. This case, the reason why this case from 2015 starts in 2015 because they have no evidence from 2014, which 2014 would make the alleged victim VR 13. 2015 would make her 14. So counts 1 through 6 is based on under 14. State will not be able to prove to you that there was any contact or messages or anything in 2014. These are called trumped up charges.
I'm going to object argument.
So just, it sustains just what you intend to show by either direct or cross-examination.
Thank you, Your Honor.
You're welcome.
So through cross-examination, through my cross of each one of them, I will show that from 2015 to 2019, there was no investigation of me. They will tell you that the officer called me and put a card on my door. They'll tell you that I returned a call. They will tell you that a search warrant, arrest warrant for me, was issued in 2016, which is over 3 years ago. But you will see with the search warrant that there was no effort to arrest or find a public figure. Someone that you can just Google somebody's house that you just went to. You think the person, I mean, if the defendant committed a crime and now you have a search warrant, and now he's such a danger to the community because it's kids in the community, you want to have them arrested. Why wouldn't you, after you get the search warrant in 2016, why wouldn't you just go to his home, arrest him, or go to his business and arrest him, or stop him when he's in his car and arrest him? Because they had no evidence of anything. They have no photos. They have no cameras. They have no they took DNA, but it came back not me. So they won't tell you anything about the DNA because they took it from me. They swabbed me. No match. So they're not going to
Your
tell
Honor,
you
I'm
guys
going
no
to
match.
object and reapproach.
There's no DNA comparison in this case, so we can't argue that. We can't say that there, and he's saying there was no match in any analysis. There was no DNA comparison in this
Sorry, like
case.
there was, so there's no analysis done.
No.
Yeah, but they took my DNA, so,
So you can definitely point that out, but
Yeah.
no testing.
okay. Yeah, it was testing done on me.
So when they take it from you, in order to do the testing, they then take a sample from the victim and they compare it. What Ms. Collins is saying, while they took it from you, they never did anything.
So
with
why
it.
didn't they compare it?
Well, that's
Something
something
to compare it to.
They owe me $3 then. They could charge me.
so just, if you want to bring that point up to the jury, bring it up, but you have to clear it up. You don't want to make it look like you're misrepresenting the facts, right? So if you can say, they collected my DNA but never did any testing.
They did do some kind of testing, they told me, because they told me, they charged me $3 for testing.
Yeah, they do it, so it's referred to a collection fee, $3 DNA collection fee. So,
Okay,
just
all
say
right,
that that was collected, no
Okay.
testing was done.
Okay, thank you.
So they have my DNA. Hey guys. I didn't resist. I said, take all the DNA you want. Do your investigation. DNA is perfect, it's flawless, proved. I said, hey, not only do you have to have my DNA, I'll take a lie detector test. I'll sit in the lie detector test with your people, and you can ask me, now you got my DNA, and now I'm taking a lie detector test. Now, you got me on two things. Prove that I did it. The state can't. You know why? It never happened. I gave the state evidence that will be shown in court, where there was numerous attempted blackmails of me.
Your Honor, objection calls for a legal conclusion.
Could you use a different word other than blackmail? Sustained.
Someone tried to get money from me. Large sums of money. And in this thing, you will see the person demanding the shopping, money, and if they do not get that wish, they are going to the police and tell them I like little girls. That's your motive. It's all the shakedown. When people look me up online, they see millions, 17 million. They know I got money. Total shakedown to try to destroy my reputation, which they have. And now the state wants to find me guilty of something that never happened. And some people find out people have money. They become targets. I've been a target for over 25 years.
Your Honor, objection, relevance, argument.
Sustained. So what evidence do you believe the trial will show? The trial will show?
The trial will show that I was targeted, and if people want money from me, the fact that I'm a very generous person sometimes does not play well for me. When I'm willing to help strangers, when I'm willing to help the homeless.
Objection, engendering sympathy, relevance.
How is that relevant, sir?
Yeah, this shows that people will come after me because I got money. And
Let's not talk about the community service aspect of it, but your money is going to be.
so the aspect of it, so when people say what people do, what you will see is you will see VR, Vanessa, that she's very intelligent. You will see that she's street smart. You will see that she has extensive criminal record. You will see that she is very provocative on her Facebook. You will see that she's violent.
Your Honor, objection, bad character, approach.
Yes.
So, there were about a dozen Facebook posts that he provided. I shared them with the court. We had the discussion about those being inappropriate character. There's been no hearing to admit those. That is what he's referring to. Trying to give him all the leeway, but he just refuses to listen to the court's ruling. So,
So, you can't just bring up that character evidence about somebody pursuant to NRS 48.045. So if you wish to present what's referred to as bad character evidence, that someone's violent, that they're a bad person, that they do drugs, things like that, then you need to file what's referred to as a bad acts motion pursuant to NRS 48.045. Then you have to have a hearing outside of the jury in regards to whether or not it's relevant, whether there's basically three different factors that the court needs to consider. One of those is the probative value and the probative value versus the prejudicial effect. So for right now, those things are definitely not going to be discussed in the hearing. Thank you, Mrs. Davis.
In the DA's opening statement, she said, I met Vanessa online and met her at What a Burger. I've been living in Vegas several years, and I have yet to run into what a burger is. What restaurant that is, where it's located, I have no idea. Somehow, this Whataburger is seems to be a couple of blocks from my home. Also, the state brings up copy and custody, and they bring up how Mrs. Vanessa is arrested. I will show you where people are offered deals. So if you say something, you don't go to jail. Tell us something. We'll send you to rehab. This is something that the people from Caliente will come and say, we give them deals, something I have on paper. You tell us something, you get this famous poker player, give us something on him, and he'll scratch your back. That's how it plays. Pay to play. What they're banking on, the state, is the Me Too movement, which I respect.
Objection, relevance.
So again, let's keep our opening statements in regards to what the evidence will show in this case, please. So that objection is
I didn't write, unlike the VA, I didn't spend all night.
Mr. Davis, what the evidence will show, please.
I didn't come up here with a statement. I did all this at the top of my head because it's in my head. I didn't have the luxury of getting a pen and paper last night.
Mr. Davis, what the evidence will show, we already talked about this.
Evidence is I didn't have a
The
pen and
evidence
paper
will
last night.
show, in this case, what?
So, what you will see is, one thing is I have the utmost respect for the police. I love them. think that anyone that will risk their life to protect us, our freedoms, our liberties.
Your Honor, I apologize, if you can instruct Mr. Davis that he cannot cry in front of the jury.
I'm not being emotional, and if you instruct me not to cry, that's kind of tough.
Okay, so let's stay with what the evidence will tend to show, please, and let's keep it relevant.
I'm keeping it relevant.
Mr. Davis.
I'm sorry, Your Honor. So when an officer is willing to go on the stand and open himself up for impeachment, I find that hard to believe. Our law enforcement is to be respected. But you'll see the Metro Prophecy statements to blow up police stations, to hurt them. And you cannot just say, because a child, I didn't want to come to court like this. I wanted to come to court in front of you in my military outfit.
Approach. You continue to just ignore the rules that I have respectfully put in place. You know that it's a law that you cannot come into court in your uniform.
And I respected that.
I know, but I told you in my album that you were in jail last night for psyche belt. You're trying to do that. You're trying to let them know about your service. That is not relevant in this matter. Those are things that would be protected that you could speak to me about. But whether or not you serve in the military is not relevant to this jury. What we're talking about is, here are the crimes charged. Did they or did they not happen? Okay? That's what the evidence will or will not show. You have to keep your argument, your opening statement in the confines of those parameters. This is not argument. This is an opening statement. So if you want to say the evidence will show this, the evidence will show that. Your feelings about the police, the fact that you were in the military, those are all not relevant.
So all the bad acts, oh yeah, because you allowed it in, I'm sorry.
Okay, so please continue.
Charge the jury that it was his choice to wear what he's wearing today in court. It
Yes.
was no one else's choice. What he
I
just said,
agree with
I
you.
didn't want to wear
I
what
agree
I'm
with you.
wearing.
I'll
So
tell
you
them.
need to clarify that.
So I'll tell them.
Thank you.
Sorry.
So, I got assigned to jail last night. I was offered a suit to wear in court, opposed to jail boots. I said, no, thank you. I don't want to hide anything from this jury. I want them to know. The suit they were trying to get me to wear looked like Pee Wee Herman. It made me look like a pervert.
Your
That's
Honor.
what they wanted to see.
So, I'm being forced to object. I apologize to the court. I don't want to interrupt this for the jury, but he made the choice to wear what he's wearing.
Yes. So I made the choice to come before you. And what they gave me to work my blues. I don't want to come as I'm out free. I want to come in as I'm in custody. So
So the theory of innocent until proven guilty, throw that out. It's really guilty until proven innocent.
Do you have anything else to say about the facts of this case? I would remind the jurors that you're never allowed to throw that out. It's a cornerstone of our Constitution, and that every individual, including Mr. Davis, is presumed innocent until proven guilty beyond a reasonable doubt by Ms. Collins, by the state of Nevada. And so no one will throw that out because that's the law.
If a person is innocent,
No, not argument. So if you have anything else that you'd like to
Yes, I
discuss
have.
with this jury in regards to what the evidence will show, you may continue. Otherwise, you need to sit down.
okay, I'll continue.
Thank you.
In counts 1 through 9, you see similar charges of the same nature. The fact that they said this happened 10 times, I just want to see one time where there's a shred of evidence that this happened. I believe the hearsay evidence is exactly what it is. Hearsay. Gossip. I'm going to show you physical evidence, not hearsay. I'll allow the DA to show you hearsay. I'll allow the officer to say hearsay. Because obviously, there was no investigation. I'll show you that I went about my day-to-day DMV, 2 jury selections. I will show you those summons. 2 juries where I don't think if it's hard to find me, if I come show up for jury selection, where's the warrant? Because the warrant couldn't be found because there was none. There was none. So the police never acted on it. 2015 interview, 2019. If it was show, I will show you guys, there was no nothing in the report of me trying to flee anywhere, try to move, knowing that these charges are out. It's obvious I had the financial means to go anywhere I wanted to. This will show I sat at home. I went to my store. I went to my business. Because I felt I never did anything. Why would I hide? If the police called me and told me to come in tomorrow, I just come in. I don't hide from authority. I
ask you all, please keep tight notes. Because I will prove in cross, I will prove that she's lying. I will prove that she lied to the police, that she lied in pretrial, and I will prove that she lied to the grand jury. This is a fact. I will prove it. Not hearsay. And then I will ask the court to politely impeach her.
Your Honor, I'm going to object. That's an incorrect legal procedure. The court has nothing to do with impeachment of a witness.
Would you rephrase, please?
I will ask the court to charge her with perjury.
Your Honor, objection. Again, the court does not charge witnesses with perjury. These reports have to be made. Incorrect statement of procedure.
Sustained. The court is just a neutral party.
I will ask that she is charged with perjury. I will ask that Officer Martinez is charged with perjury. Once I prove it. I don't think anyone should be able to come to court of law and lie. I don't think DAs. I don't think officers. I don't think witnesses. But one person I cannot charge with perjury, which is a fact, is the DA.
Mr. Davis, is there anything else you have to say about the facts in this case?
Yes, ma'am.
Okay, so we got to stick with the facts.
So, Vanessa Robinson I would prove that she has assaults, burglaries.
Your Honor, state objection.
Mr. Davis, did you understand the court's previous ruling?
I can't say.
Okay. I just told you that you cannot get into fire acts of the victim or any witness without a hearing pursuant to NRS 48.035. If you violate my orders again, you will be ordered to sit down. Do you understand?
Yes, Your Honor.
I will not tolerate this. This is absolutely out of control.
Yes, Your Honor.
Stick with the facts. If you're done with the facts, sit down.
Yes, Your Honor.
On the record, we had previous multiple conversations that these were juvenile in nature. She is just now 18. He knows he was informed multiple times that an order had to be signed, had to go to family court. Right now, this is all speculative. I'd ask the jury that they be stricken and the jury be charged that they cannot consider that because he's repeatedly, one hair at a time, polluting them. It's really difficult to control.
Ladies and gentlemen, you are to disregard the statements that the defendant just stated in regards to the victim. You're not to consider them in any way. Also, as you remember from my instructions, anything that is said by either the state or the defense during opening statements, not evidence at all. This is what is planned to be proven, and so until you see it or hear about it in evidence, you cannot consider it. Thank you. Please proceed.
Also, the DA said contact was made on Facebook. I will prove to you beyond a reasonable doubt that the Facebook records that I have, it's not mine. The state, the
contain over 300 pages of Facebook conversation. I actually had time to go through all 300 pages. You will see in these conversations multiple people in them. But what you will see more is multiple deletions. Delete Vanessa Robinson. Delete Vanessa Robinson. Delete. You'll see more deletes on her name because they are hiding. If you really got a search warrant, why not show the whole search warrant? If you really got a search warrant for somebody's Facebook, you said you got it, show the whole conversation. Let the jury see the whole conversation, not delete. I like to know what they were blacking out.
Well, I'm going to object as to who is they. He's saying they blacked it out. Does he mean the state blacked it out?
Detective Martinez. I want to see what Mr. Detective Rodriguez blacked out. Also, it's very puzzling to me about this whole thing is since the elections happened in 2015, so that's what she laid down to you guys, 2015, so we don't have to worry about 2014. So from 2015, they said these allegations happened in 2015. And in the lineup, they would tell you it was a lineup somewhere between 2015, I guess, to 2019. I would prove to you without a reasonable doubt that I had not been in any lineup in over 15 years. Take that. I haven't been in a police lineup in 27 years. So I would like to know who they lined up. I would prove beyond a reasonable doubt to all of you that this is the state trying to frame an innocent black man. Frame. Because you would not find a lineup in me lined up anywhere. The state will say that Officer Martinez's way of providing the lineup was he took a bunch of photos, black males, and he mailed them. Just think about that. He mailed them to a juvenile facility, and he said, check out who did this to you. She picks out the defendant. You don't go get material. You gotta mail it back. I would prove to you, beyond a reasonable doubt, that VR wasn't on just marijuana. I got it. I got the report. Methamphetamines, crack cocaine.
Same objection, Your Honor. I don't know how many times we're going to have to have
morning. Ladies and gentlemen, you are not to sustain any other evidence presented by the victim or witnesses in this trial.
You will see the state continue to try to take things out so you guys can't see it. Because the things they want you not to see is very important. It will be very seldom, if at all, that I would object to anything they want to show. But there will be a lot of objections to me.
Is there anything else about the facts of this case?
Yes.
Okay, then I need you to get to them.
So, the state knows for a fact the wealth I have obtained. But for some reason, with all the money I made, $17 million, I never bought a car. You will never see a car. How, if there's no car, how am I getting to these places? Remember that key point. I had a license. I have had a driver's license since I was 17. I have had a car my whole entire life. But you never hear no mention of a car. I'm lazy. I hate to walk. So, I just want you guys to remember that fact. Key thing, car. This case I will show plenty of contradicting statements. And in 2016, I don't know who won the Super Bowl. I have no idea. I bet it, and I still have no idea who won it. In this case, you will see a phenomenal genius IQ with Vanessa Robinson. Me, I don't remember dates. It's hard for me to remember certain dates. So, I applaud people who have photographic memories. But I will prove beyond reasonable doubt she's not one of them. But there are certain dates that she remembers. And those dates that she remembers, and tells you, I will show you it's impossible for me to have been impossible. Thank you guys for your time.
Thank you, Mr.